Legal privilege, particularly in the context of health and safety, is the concept where certain types of documents and information can be withheld from a court or from the health and safety executive, or indeed another party suing the organisation, because they are restricted in a particular way. And there are two types of legal privilege. One is legal advice privilege, which is advice given properly by a lawyer to the board of a company and is proper legal advice. That is somewhat similar to actually your solicitor advising you during a police investigation. The police are not allowed to see what that advice is or what your solicitor has advised you to do. The other type of legal privilege is litigation privilege, where there are maybe documents or reports, meetings held, information of that sort, which is undertaken in anticipation of there being some legal proceedings. Now, many organisations actually just fail to recognise how easily they can create a whole series of documents when an incident has occurred, which they imagine are going to be confidential to the organisation and are then subsequently obtained by an enforcing authority, the health and safety executive or someone bringing litigation, and are recovered on the basis of them being relevant to that investigation. So, for example, if a director of an organisation is aware of an incident and asks for one of his staff to produce a warts and all report on what has happened and get it to him very quickly, particularly after a serious incident, this can be a very bad idea, because immediately the rushed report with the warts and all that the person might even add into it actually is then going to become available to the health and safety executive or to someone bringing a civil action. The appropriate response, particularly after a serious incident, is for the director to get the company's legal advisors to instruct someone, either an external party or an internal party, to produce a report in anticipation of proceedings. And provided that is marked legally privileged and confidential, provided the lawyers are involved at every stage, and provided the true dominant purpose of that report is for defending legal proceedings, and there is a reasonable prospect of such proceedings, then there is a good chance of keeping that confidential and legally privileged. But many people seem to think that they can write legally privileged and confidential on something and it will in some way protect it, and it will not. And similarly, that information has to be kept quite confidential. The moment it's circulated around the company, legal privilege will be lost. So it's important to take advice at an early stage, particularly when there's been a serious incident, before all sorts of documents are generated which may be prejudicial, actually don't reflect the true circumstances, and are not prepared with the thought and independence needed.